Hi there, my name is Jonathan Ginsberg. I'm a Social Security Disability attorney, and today I'd like to talk a little bit about attorney's fees, and specifically to answer a question that was posed to me by a woman named Maggie. I put out a video a little while back where I asked people to submit their most important questions about Social Security Disability, leave it in the comments. I encourage you to do that if you've not already done that. But I got a lot of great comments, and one from Maggie, and basically what she said was that she's recently hired an attorney to represent her with her SSDI case. The attorney only collects a fee based on past due benefits I may receive. I think my case is strong. Now I think maybe I should have looked for a fee-based attorney. What do you think? Here's my take on that. First of all, I think in the disability world, most attorneys are going to take cases under a contingency fee agreement. And the reason for that is really somewhat practical. First of all, if you don't do a fee agreement that calls for 25% of past due benefits, currently with a cap of $6,000, the only way to get paid is to file a fee petition where you keep your hours, and based on your hours, you ask the judge to approve a particular fee. Now, Social Security will withhold 25% of your benefits, and then if the fee agreement is approved, or the fee petition is approved, they will release the funds. The problem is that Social Security is so behind that if you submit a fee petition, it may take 2 or 3 years before it's acted upon. And during that 2 or 3 years, and I know this because I've submitted a couple in cases where there were 2 attorneys or where my fee agreement was not approved for some reason, you have to keep bugging them. Social Security judges have a lot to do in making a decision, reviewing somebody's fee application. It's just not a priority. So in my experience, I would submit a fee petition. I'd hear nothing for 6 or 8 months. Then I would email the judge or leave a message. I still might hear nothing. And I might have to make 10, 15 phone calls. I might have to write the chief regional judge to say, I need some help on this. So, and again, I'm not blaming the judges. They're busy. They got a lot of stuff to do. And that means they've got to pull an old file, review that old file, then look at my fee application. I'm sure there's a lot more things they'd rather be doing than that. But as a practical matter, it's not a viable thing for me to have to go through that. So it's much easier to submit a fee agreement where I'm getting paid 25%. Essentially, no one's looking at your hours, but the judge either will approve it or not based on what the language of the fee agreement is. And of course, everybody uses pretty much the same type of fee agreement, so it's almost always approved. The only time they're not approved, by the way, is if you've had more than one attorney and the first attorney will not waive fees and withdraw and waive fees, or for some reason there is something really unusual about your agreement, although again, I've used the same one for years and years and I pretty much never had it rejected. So that's one reason. It's just not practical to do a fee petition, and nobody wants to voluntarily, or I don't know anybody who'd want to actually do that. The second thing is that when you take a case, as an attorney, when I take a case, I'm basically offering my client my expertise, not really my time. I mean, the analogy, maybe it's not a great analogy, but it would be that when you hire a brain surgeon, you're not hiring him to, for his physical capacity to saw or his time. You're hiring him to know where to saw and what to do when he's got your brain exposed. So I think it's the same thing with attorneys. You're not hiring me for the hour and a half that I'm in your hearing. You're hiring me for knowing how to ask the right questions. You're hiring me for evaluating your case and knowing how to get the right medical information prepared, and preparing you to answer the questions the right way, and knowing how to do a direct examination and cross-examining the vocational witness and responding to the judge's inquiries and knowing about the judge. There's just a lot of stuff. There's an art to it. It's really what it boils down to. So, if I take a case, and I've had this happen a few times, I'll get a hearing. I'll give you an example. I had a case that somebody came to me the Friday before the hearing. Hearing was on Monday. They came to me on Friday. And my first thought was, well, there's no way I'm going to have time to get this case ready. I'm going to try to get it postponed. So I called the hearing office and said, I just got retained today. The hearing's Monday. Can I get this hearing reset? And the judge, the person who answered the phone said, let me check with the judge. I'll call you back. Calls me back. No, this case has been reset 3 times. The judge wants to go ahead with it. So So I'm thinking, I haven't reviewed the file. I don't even have the numbered exhibits. I can't log into the electronic system. I've literally got just a suitcase full of records. I don't know what the numbers are. I can know what the dates are, but I'm gonna have to spend all weekend going through this. So I did spend a good bit of time over the weekend, several hours, going through it. So I got a sense of what was going on. Got to the hearing. The judge was a little bit apologetic, like, I understand that you're kind of on the spot, but I'm not going to delay this anymore. But I knew the case, and I talked to my client fairly, we spent a good hour and a half together before the hearing, just going over what was what. So I kind of knew what was going on. And I've done this for a long time. So I probably had, I don't know, maybe a total of 7 or 8 hours total into this case, if that, maybe even a little bit less than that. And at the hearing, the judge was a little bit aggressive towards my client, and you could tell he was not very happy with it. But I had some good facts on my side and some good evidence, and so, I was able to develop a pretty strong direct examination. I was able to get my client to bring out some information that was very relevant. I had his wife testify about some of the issues he'd been having. There was PTSD involved in it, and just to bring some information out the judge didn't know. This gentleman had been born in a war-torn country, and he was impressed into an army when he was 9 years old and forced to kill people and saw a lot of death. And none of this is really in the record. And so you could tell the judge was like looking at me and listening to it. And we ended up getting a favorable decision. Not only a favorable decision, the judge reopened 2 prior applications, and this gentleman got back benefits going back 10 years because he had a date last insured issue and so forth. But, he got tens of thousands of dollars. And obviously, it was his case, and he's the one who went through all that. I like to think I had some part of that. But, if you said, okay, how many hours did you spend, and, what's your hourly rate, I would not have gotten paid the same amount of money. I would not have gotten $6,000, which is what my fee would be for a contingency fee. And my feeling was, I basically took a case that was going to get denied and got it approved because I knew what I was doing, I knew what to ask. So my time in that case was not really an accurate representation of what I did. So to answer Maggie's question, sometimes, the attorney does is not just a function of time, the hours he or she puts in. It's about knowing what to do and how to approach it. So I think that, my sense is that she would have a difficult time finding a lawyer who would do a case on an hourly basis because of the fee petition problem. And again, because these cases, there's a limited dollar amount on the fee. It's somewhat of a volume practice. So we also have an issue of, am I going to take a case where I've got to do essentially the same amount of work preparing for a hearing when someone says, well, I'm just going to pay you, I'll offer you half, I'll pay you $3,000. I'm just going to say, no, not going to do it. There's enough cases where I can get my full fee because at some point I've got to stay in business and I've got to get paid for my time and pay my staff and keep the lights on. So, Social Security, again, you're not going to get rich as an attorney doing Social Security disability. So, with all due respect to Maggie, this is an area where you need to know what you're doing. It's not about how much time. It's not it's not like you're doing data entry. There's a real skill to this and an art to this. So I think finding an attorney to do it on contingency is really the more fair way to do it. And one of the things she also said, and again, I'm not doubting her, she has a strong case. Well, everybody has a strong case. Everybody walks in thinking they've got a strong case. But I will tell you that there's weaknesses in every case. And sometimes there could be serious weaknesses in a case that you may not realize are weaknesses. So, of course, you think you have a strong case. Obviously, you wouldn't have pursued it if you didn't. But, what you're buying from an attorney is experience, expertise, knowledge, strategy, tactics, all that type of stuff. So that's why I suspect Maggie would have a difficult time finding a lawyer to take a case on something other than a contingency fee, and why, in my humble opinion, a contingency fee is a fair way to get the value of an experienced attorney without coming out of pocket and also without putting the attorney through the hassle of having to file a fee petition. So hope you found this helpful, and I hope this does explain a little bit about how attorneys get paid and why we approach it the way we do. If you found this video useful, please please give it a thumbs up on YouTube, like it on Facebook, leave me a comment. Let me know, what do you think? Do you think I'm all wet about this? Do you think that there's should be different ways that attorneys get paid, or is it unfair? Again, I'm happy to interact with you. I've got my opinion, but again, other people have different opinions about these sort of things. If you'd like to download my Secrets to Winning Disability Survival Kit, you can do so at ssdanswers.com. I also will give you a free case evaluation, although only if you're not represented. Again, if there's been more than one attorney, you typically can't get your fee agreement processed, and I'm very respectful of all the other attorneys. If somebody has a case, another attorney is working on a case, and somebody calls me and says, it's been 2 years, I'm really frustrated, I want to hire you, I saw you on YouTube. First thing I say is call your attorney, work it out. I don't go after other people's cases. I wouldn't want them to do it to me. And most of the time, the reason that people are frustrated is the amount of time, which has nothing to do with the attorney. So again, if you're not represented and want a case evaluation, happy to give that to you. So for now, this is Jonathan Ginsberg, and I do wish you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the Survival Kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.